We are back talking with Mike Wells about estate planning. He's going to be one of the many lawyers there on For All Service Day on Friday, where you can get free legal information. All right, Mike, let's take some of these questions here. This person is asking, do you have to pay for a will, or can you make a will with a notary?
The only person who can prepare a will legally is a lawyer. Now, you can prepare your own will, but I would suggest that you not do so, because there are some very technical provisions that on which you can kind of, stub your toe, so to speak. A notary has no legal authority to, quote, give you legal advice about preparing a will. Now, people can do their own will in their own handwriting. If it's in its own handwriting, you're competent at the time, and it's found basically with among your important papers, and you signed it, as I say. It can be legal. A lot of people don't realize that. So when people try to do that on their own, it can very well be legal. And I've seen any number of wills where somebody has written it out, and it's legal under North Carolina law, and in most states as well.
I found it interesting that you don't file your will with the court. They wait until your death to do anything with your will.
Correct. It's not on public record until you pass away, when you file it to say the person has passed away, and then the estate administration proceeds. But a lot of people think that. That's a common misconception, that your will and your wishes are on record at the courthouse, but that's just not the case.
So then I guess the people then want to know, how do you connect the dots? So what happens then, like when you pass away? Is it whoever was the executive of your will, they're supposed to find your paperwork wherever it is?
Correct. In other words, if you have a will, you need to make sure that your loved ones know where it is. If you can't find it, you die without a will. So generally, folks will keep it in a lockbox, or maybe they'll keep it in some other safe place. If they have a lawyer, more often than not, the lawyer will agree to hold on to the original will for you as a courtesy without charge, so that folks will know where it is when somebody passes away. So when someone passes away, the person in charge of the estate is often called an executor or administrator, and then that person would, quote, file the will at the courthouse with the clerk of court, and gather up all the assets, gather up all the bills, pay the bills, and then distribute what's left to the heirs named in the will.
Okay. This person is asking, if we had a will drawn up in Ohio, is it still valid in North Carolina?
A will in another state under North Carolina law can be valid in North Carolina. This was a welcome change by the legislature a few years ago. If someone has a will that's valid in the state in which it was signed, it would not make a lot of sense to say, well, there's some technical rule why you can't, if it was validly done in that state. So a will done in Ohio, if it followed all the rules when it was signed and executed, it can be and would be valid in North Carolina.
All right, this next question is, what happens if you have closed an estate, but then you receive a check in the deceased person's name as a refund from a medical bill? What do you do with it?
This happens from time to time, where an estate is closed and you find an additional asset, and there are ways for an estate to be opened up depending on the circumstances. Sometimes that's not always necessary, but it can be opened up and the money's distributed pursuant to the will, and it can be a fairly simple procedure when that happens.
And what do they need to do? Do they need to go to their lawyer, a bank?
They probably could go, honestly, depending on the size of the check or the asset found, go to the clerk's office. Now, you probably want to mention that to your lawyer. Your lawyer's paralegal may be able to do it for you as a courtesy for a small amount of money. But it's not a big deal. It's not an expensive deal, even if you have an attorney who's helping you in the matter.
All right, and just quickly, how can people start the process of gathering all the documents that they need for a will?
Actually, it's pretty simple. You just have to call your lawyer or find a lawyer, set up an appointment. The lawyer would ask you to fill out some pretty simple paperwork. You know, what's your name? Are you married? Do you have children? Whom do you want to be in charge of things? And set up an appointment and go. It is overwhelmingly the single most important thing. 95% of the time. If you set up an appointment, go see a lawyer, the process gets started. The lawyer can help you fill in the gaps. It's the single most important thing. Having given hundreds of talks on this topic, that is the ticket. You got to get started, sit down, and then the lawyer can figure out the rest of it once you get started in the process. And
Gotcha.
a lot of times lawyers, certainly North Carolina Bar Association lawyers, will meet with clients as a courtesy, even though it may be a new client.
Okay, great. Thank you so much for your time. We appreciate it. And I know that Mike is going to be one of the many lawyers there on For All Service Day. We wanted to put up the number one more time before we go today. You can see it there at the bottom of your screen, 355-6262. That number is going to be operating on Friday.